Welcome to the Texas Business Law Reporter, your brief on the business bench. We bring you the latest Texas business law cases and rulings, distilled into straightforward, bite-sized updates for busy business lawyers. Sponsored by Rydell Law Firm, this podcast is crafted by expert Texas business attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify, and join our professional community on LinkedIn. Texas Business Law Reporter, clear, concise, and current. Today we are exploring the latest Texas Supreme Court decisions in June 2024 involving contract interpretation, premises liability, product liability, and intentional torts. We will explore the key details of these cases. Let's get started. In Board of Regents of the University of Texas System vs. IDEC-X Laboratories, Inc., the issue at hand is whether the royalty provisions in a licensing agreement are ambiguous. IDEC-X Laboratories, known for developing veterinary diagnostic tests, including those for Lyme disease, originally paid the University of Texas a 1% royalty based on their licensing agreement. However, the university contended that the appropriate royalty rate should be 2.5%, leading to legal action. The crux of the dispute revolved around differing interpretations of the contractual terms related to royalty payments. Initially, the trial court sided with the university, ruling for the higher royalty rate. However, the Court of Appeals reversed this decision, deeming the provisions ambiguous. Upon reaching the Supreme Court, it was ultimately determined that the provisions were not ambiguous and should be interpreted to uphold the higher 2.5% royalty rate. The court stressed that ambiguity in contractual text requires more than just a disagreement over its interpretation. It must be genuinely uncertain. Consequently, this ruling highlights the necessity for clear, precise contractual language and the importance of understanding the context in which contract terms are drafted and applied. For Texas business lawyers, this case serves as a pertinent reminder to meticulously draft and review contract language to avoid costly disputes and ensure that agreements are airtight and comprehensively clear. Up next, in Pay and Save, Inc. v. Canales, the court tackled whether a wooden pallet used to transport and display watermelons constituted an unreasonably dangerous condition. Roel Canales sued the store after tripping over a pallet and breaking his elbow. Initially, the trial court awarded Canales over $6 million, but the Court of Appeals reversed that decision, and the case made its way to the Supreme Court. The Supreme Court ultimately sided with Pay and Save, ruling that common conditions like wooden pallets are not unreasonably dangerous per se. The court emphasized that to prove a hazard is unreasonably dangerous, plaintiffs must present more than just the possibility of harm. They need tangible evidence, such as previous accidents, complaints, or regulatory issues, that elevate the risk to a dangerous level. In this case, Canales failed to show such evidence. This ruling reaffirms the necessity for plaintiffs to do their homework and demonstrate specific circumstances that transform an otherwise ordinary condition into a substantial risk. For business lawyers advising clients in similar premises liability cases, this decision highlights the crucial importance of evidence in substantiating claims of unreasonably dangerous conditions. Moving on to the next case, the case of American Honda Motor Co. v. Milburn, the central issue was whether Section 82.008 of the Texas Civil Practice and Remedies Code provides Honda with a rebuttable presumption of non-liability for design defects. Milburn, the plaintiff, argued that the seatbelt system in the 2011 Honda Odyssey was defectively designed and confusing, leading to severe cervical injuries when an accident occurred. Despite the jury initially siding with Milburn, the Supreme Court reversed the lower court's decision in favor of Honda. The court concluded that since the design of the seatbelt system complied with federal safety standards, the statutory presumption of non-liability applied. Moreover, Milburn failed to demonstrate that these standards were inadequate to protect against unreasonable risks. This ruling highlights the challenges plaintiffs face in overcoming such statutory presumptions of non-liability when sufficient and detailed evidence of federal standards inadequacy is not provided. Last but not the least, in Keys v. Weller, the central question was whether corporate owners can be personally liable for torts, despite acting as corporate agents. David Weller spent several months in employment negotiations with Monocoque Diversified Interests, LLC, wholly owned by Mary Keys and Sean Nadeau. After accepting the employment offer based on certain compensation terms, Weller later found a dispute over the owed compensation and subsequently resigned. He then accused Keyes and Nadeau of fraud, alleging they were personally liable for their tortious conduct in misrepresenting the compensation agreement. The Supreme Court ruled that Keyes and Nadeau could indeed be held personally liable for their tortious actions, despite acting in their roles within the corporation. The court's decision explained that Section 21.223 of the Texas Business Organizations Code, which limits the liability of corporate shareholders and LLC members for matters related to corporate contractual obligations, does not shield corporate agents from personal liability for their tortious conduct. Because Weller's claims stemmed from Keyes and Nadeau's actions as monocoque's agents rather than just as owners, they were not protected by the statute. This ruling has critical implications for corporate officers and agents in Texas, underscoring their personal accountability for tortious conduct, irrespective of their corporate roles. Texas business attorneys should advise their clients that personal liability can attach to corporate agents who commit torts, even if those agents are also owners of the corporation. Thanks for tuning in to the Texas Business Law Reporter, your brief on the business bench. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Rydell Law Firm, your trusted partner in navigating Texas business law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.